Welcome to We Get Work and the Year Ahead 2025 podcast series. This year, our special report and corresponding podcast series are created to help you move forward steadily, seamlessly, and successfully in a workplace law environment in persistent flux. Jackson Lewis invites you and others at your organization to experience the report's legislative, regulatory, and litigation insights in full at our website, jacksonlewis.com, or listen to the podcast series on whichever platform you turn to for compelling content.
So thanks, Alicia. I'm Eric Gittig, and I'm here with Laura Besser. We are on the Jackson Lewis's California Class and PAGA Action Resource Group, and we are here today to talk about PAGA. PAGA is what I think one of the least just and fair laws that employers are dealing with today in California. And they pose a number of problems for California employers. And despite the new amendments, which we're going to talk about from June of this year, they're still very problematic for employers. So, Laura, do you want to start talking about the amendments a little bit?
Sure. Thanks, Eric. So I understand the PAGA is a statute that's not employer friendly, but one of the benefits of this last year is that we had some amendments come through that did kind of, for lack of a better phrase, throw employers a little bit of a bone when it came to dealing with PAGA cases. So one of the benefits that we have seen from these new PAGA amendments is an expanded ability to cure labor code violations. And the new amendments treat curing of these new expanded ability to cure labor code violations differently based on the employer size. And the concept, or the idea behind it, is that the legislature was trying to give smaller employers a little bit of a better leg up and being able to defend against these PAGA claims. So smaller employers, meaning less than 100 employees during a putative PAGA period, which is 1 year and 65 days prior to filing of the PAGA complaint. And that those smaller employers are now able to cure any labor code violation that they want to. And that process of doing so is to be brought up through the LWGA, the Labor and Workforce Development Agency, by filing a confidential proposed notice of a cure, and how walking the labor code, walking the labor LWGA through how they are going to cure these alleged violations. So now that the one benefit is they can cure any labor code violation, as opposed to previously it was just wage statement violations. Larger employers, those more than 100 employees, are also able to avail themselves to the cure process. The mechanism is just a little bit different. Now they have to go through an early neutral evaluation conference and present that to a judge or a magistrate, how they are proposing to cure, and have that kind of blessed by the magistrate or the judge prior to implementing that. But that's one of the benefits upside to the PAGA amendments. Eric, go. I think you might want to talk about a little bit about penalties, maybe.
Yeah. So the other potential benefit for employers, is that there were some penalty caps that were imposed. So whereas prior to the amendments, the penalties that the civil penalties that employers could face were either $100 or $200 per employee per pay period, now there's the option to cap these penalties at 15% or 30% based on a showing that you took all reasonable steps to comply with the labor code. And the 15% cap is if you took the reasonable steps before getting notice of a PAGA action, and the 30% cap is if you have a plan in place after receiving notice that a PAGA notice was filed against you, that you are going to be taking all reasonable steps to comply with the code with respect to the allegations in the PAGA notice. So what all reasonable steps means is kind of up for debate. And that's something we expect to see a lot of litigation on in the next year and probably longer. The labor code does give some examples of reasonable steps. It's a non-exhaustive list, so it's going to really come down to the judge, as to whether those caps are going to be put into place. The four things that the labor code does mention is an audit of time and payroll records, having compliant written policies, having manager training of the relevant labor code provisions, and also disciplining supervisors and managers who may have a hand in causing labor code violations. But when these are going to come into play, at what point in a PAGA case, we don't know. And there are some pros and cons, obviously, to trying to take all reasonable steps in terms of an attorney-client privilege issue. That's something that if you do get a PAGA notice or you do have concerns that there are labor code violations, we strongly recommend talking to your attorney, your in-house counsel, to see what can be done to cap your penalties, either in a PAGA case going forward or one that is currently happening right now. But those benefits, a 15% cap, is obviously a huge potential benefit for employers. Laura, you want to talk about some other benefits to the from the PAGA amendments?
Sure. Yeah. Thanks, Eric. I think the main benefit, out of all, is a standing requirement. So prior to the PAGA amendments, standing was kind of in flux. Standing meaning whether or not an employee actually has to suffer a labor code violation to bring a PAGA claim regarding that labor code violation. Previously, an employee could have been an exempt employee and trying to represent non-exempt employees, with their meal and rest break claims, things of that nature. And so many courts were allowing cases like that to proceed. And now the PAGA amendments has been amended to require the employees to actually have suffered a labor code violation to represent a claim on a representative basis, which is a significant improvement for the employers, just because now the employees can't just bring an amorphous claim that covers all potential labor code violations. They actually have to have suffered a violation.
Yeah, and the fact, to me, the fact that you have this standing requirement, or the fact, I should say, that you didn't have this standing requirement prior to the amendment, says just about everything you need to know about PAGA and doing business in the state of California. I've seen, just despite the new amendments, you still have some attorneys who are sending you these PAGA notices with 27 violations, alleged violations in it. Some of them are, when it comes to the actual complaint, limiting the complaints for standing purposes. But as I mentioned earlier, what we expect to see going forward is employers and plaintiffs pushing the limits of these amendments, and finding out when these potential benefits to employers are going to come into play. So, for example, the standing requirement. Is that something you're going to be able to make a motion for early on in the case if there's a standing issue? Is it something you're going to have to wait until trial? Manageability is also something that was covered in the amendments. Is that something that's going to have to wait until the time of trial, or is it something that you'll be able to make a motion to help limit discovery? I mean, these are things that we expect to see litigation on in the year ahead.
Right. Yeah. Right, Eric. Yeah. And another thing that to keep in mind too is the impact of arbitration, the employer's ability to compel arbitration in light of the PAGA amendments. What it appears to be is that employers are going to have to choose whether or not they're going to avail themselves to the cure process, these larger employers, through the early neutral evaluation process, as opposed to going through and getting the stay on arbitration. Several courts have already indicated that if the employer is going to avail themselves to that E&E process, then they are availing themselves to the forum, and they're waiving their right to be able to compel arbitration. Again, that E&E process is where an employer can, try to cure or bring to the judge or the magistrate their labor code violations and the alleged labor code violations, their defenses, and try to resolve the claims and get a stay in the action until that happens. But if they do that, then many courts are saying that they've availed themselves to the forum and cannot compel arbitration. So looks like it's gonna be one or the other on that.
Yeah, Laura, and we'll talk a little bit about the state of PAGA versus arbitration in a little bit. But the other thing that I want to talk about in terms of the amendments is that we have seen an uptick in investigations by the LWDA in response to PAGA notices. So PAGA notices, they're filed. A plaintiff has to wait 65 days to file a lawsuit after that notice has been filed. And that 65 days is to give the LWDA time to decide whether it wants to investigate on its own. And prior to the amendments, I had never heard, or maybe I'd heard of one situation where the LWDA attempted to investigate. They ended up not in that situation, and the lawsuit proceeded. But I've heard of at least 3 situations now with clients of the firm who are getting notices from the LWDA where they're requesting records following a PAGA notice under their subpoena powers. These requests for records are not going just back the 1 year under the PAGA limitations period. They're going back three years. So it's something to look out for. And then the other thing to look out for is just the impact on these amendments on settlement values, or on case values in general. Because, in theory, you have these penalty caps. They should help employers who are looking to try to resolve these claims get out of them at a fairer value, if there is such a thing. And, they should also help in terms of, employers trying to push it who do want to fight these claims, and hopefully give them some tools to fight it prior to trial, which was one of the big problems of PAGA pre-amendment, is that you really didn't have any options to fight these claims prior to trial. So one other, I guess, development in PAGA that happened was the ability to settle out PAGA cases, which took a step forward for employers. Wouldn't you say, Laura?
So yeah, another case that came out this last year that we're going to look to the impact to going forward in 2025 is Turieta versus Lyft. That was a case that that the court had ruled that PAGA plaintiffs do not have an automatic right to intervene in, object to settlements, or move to vacate judgments in other PAGA cases with overlapping claims. And the significance of that case is that now it allows us to settle PAGA cases or PAGA violations, alleged PAGA violations, with more desirable opposing counsel without that risk of having to defend against motions to intervene or objections to settlement. So I think that's one benefit that we're going to see a lot more this next year. A lot of more defense counsel getting more bold with, trying to find the better deal for their client to settle these PAGA cases.
Yeah, and the flip side to that, Laura, is of course that you're getting, at least I'm seeing, a lot more plaintiffs' attorneys filing on top of each other in the PAGA cases. So I think, whereas before you may have had people who are less willing to file on top of another plaintiff once there's litigation pending, now, there's just filing after filing after filing, because even the last to file plaintiffs' firms know that the company could negotiate with them directly if they're willing to be more reasonable. So, sometimes that works out in the employer's favor. You're able to negotiate with a more desirable, settlement partner. But for those employers, who may want to fight, or depending on, the plaintiffs' firms that are filing the claims, there can be some negative adverse, impact of these multiple filings in a PAGA case. One of the things which I alluded to earlier that I do want to touch on is also the state of PAGA versus arbitration. There's been a lot of developments in the last few years since the Viking River case. Going forward to the Adolf or Uber case. But one thing that we're looking at now are, whereas before you were getting a lot of PAGA cases where we were trying to get them either dismissed at first and then at least stayed with pending a motion to compel arbitration. Now we're looking at whether courts are even going to enforce arbitration agreements with respect to the individual components of a PAGA claim. A lot of plaintiffs are trying to get around this, and some courts are permitting it. So in the year ahead, we do expect to see potentially some appellate decisions on that to kind of clarify whether you can do that or not. And, at least one good development recently in 2024 this was the Rodriguez v. Lawrence Equipment Inc. case, is that a court did rule that if you do compel the individual component of an arbitration, the individual component of a PAGA case to arbitration, and then you defense the claims in arbitration, that plaintiff will no longer have standing to to pursue the PAGA claims on behalf of the representative group, the non-individual group. So it is, a strategy for employers. We see a lot of plaintiffs who were at a company for a week and a half, even if that, bringing these PAGA claims on behalf of all, 5,000 or more employees in California. If you have somebody who was there for a limited amount of time, or even not limited, but you're able, to defend the claims, you're able to get out of that PAGA claim.
Right. And Eric, one thing that I've been seeing a lot, and I'm sure you have too, is that plaintiffs' counsel are now filing representative-only cases without seeking any individual penalties to try to circumvent that Rodriguez ruling and, losing their standing, which is one thing that we're going to see more at the court's ruling on next year, and kind of seeing whether or not they can actually do that.
Yeah. So Laura, I think, in terms of closing thoughts, PAGA still horrible, still a bane on the existence of California employers. But, for the first time, potentially there may be some light, in terms of the amendments and our ability to fight these claims and not just have to wait to trial to do it. So you have employers who don't have to make the decision of settle out right away or, go all in terms of trial. So there is some hope for employers in the 2025 year. Right.
I agree, Eric. If an employer is well prepared with arbitration agreements and now with these PAGA amendments, I think they can at least defend against these types of cases and put themselves on equal footing, I think, going forward.
Yeah, especially with the reasonable steps. There's things that you can be doing for just on an annual basis to protect yourself, if a PAGA claim is filed against you, which is a good thing for employers.
All right. Well, stay tuned for more content to come. Thank you all for joining us.
Thank you.
Thank you for joining us for the Year Ahead 2025 Special Edition podcast series. Please tune in to future episodes where we will continue to tell you not only what's legal, but what is effective. Our We Get Work podcast is available to stream and subscribe on Apple, Spotify, and YouTube, as well as jacksonlewis.com. If you enjoyed these episodes, we encourage you to share any or all of them with your network and leave a review to help others find us. We would love to hear your suggestions for future topics, or if you're interested in being a guest on our show, please reach out to us at wegetwork@jacksonlewis.com. Thank you for tuning in.